While it's regarding this the confusion regarding the demand notice, while it says the mining officer. Well, it's regarding the confusion in the demand notice which has been challenged by the petitioner. I've called the mining officer to office to clarify on the same. So if we kindly be listed in this Tuesday, I'll apprise the lordships.
No. Tell him to come at 2 p.m. when he is coming today. So what? Yesterday when you said then he is coming today, then he has to come in the morning.
Yesterday, I did not meet minutes.
No. Then we can't accommodate. Then we are going to dispose of them.
So whatever instructions I received, your lordship.
In this matter, we directed the GA to appear.
It's not this one, that is another matter. This matter also, my lord, I was discussing with my friend. Here the royalty has been charged and the minerals have not been removed. That is
what is there.
So regarding that,
The incident of charging the royalty must arise.
Yes.
If it has not arisen, then what?
but because can only be charged.
Either you change the law, you have a legislative power, or if you have framed the law, then you should respect the law.
It can only be charged on removal or
That
consumption.
is what is made.
When the rule says and the act of
Absolutely. That is what I am saying. So what he is doing?
regarding that demand only, my learned friend has called the mining officer to.
What for? He has charged the royalty without the removal. Can he do it? That is what we wanted. We wanted to inculcate, read the law. When you are there, then you should know the law. What is the law? You can't act as per your own whims.
Section 9 of the MMDR Act as well as 32(4).
Correct. Everything is very clear.
That is clear. Only regarding that doubt whether how.
What doubt?
Because so far as in that demand notice, they have also charged the dead rent. Dead rent definitely
Can be. Can be. There is no difficulty. You should charge the dead rent.
Only that royalty, how they have charged that regarding
And the
that.
royalty is a major component.
Yes.
Yes.
So
The major. Or else your lordship may direct set aside so far as the royalty is concerned.
no, they should know. Sir, every day why the court would be burdened with these kind of an orders which is absolutely palpably against the rules, against the act. Then we'll have to make that there should be some kind of a orientation program. There should be some kind of a symposium to be held to make them aware that what is a law. Series of judgments are there. They don't know.
Against this demand, my learned friend has also filed a objection representation before the authorities. Now,
Sir, representation theory, you know.
not on representation, my lord. Let the authorities recalculate.
Recalculate means what? Unless they know what they will recalculate. They do not know law. They do not respect law.
Earlier, these lordships had laid down the.
Have they read? Have they read? I am asking you, earlier we have laid down the law. Have they read? Had they read the judgment, I think they would have corrected themselves.
Last week, the judgment was passed.
That would have been the reason. Call him, appear at 2 p.m. No.
This is difficult.
No, this is how far.
Dispose of the matter today. Of the matter.
No.
Today then.
No.
It's 2 p.m. and it's more is very far.
Tell him to appear virtually. Tell him to appear virtually. Immediately informed him. Come at 2. Let him appear virtually.
I have filed a memo withdrawal. In item number 2, I have filed a memo for withdrawal of the writ petition.
What do you say? This is the old one.
come from the person, if they want to withdraw million, then I have no objection.
Yes.
If they want to withdraw million, I have no objection. It's up to them. It's come for the first time.
Interim model.
It was there, that's why I'm asking.
18/10/2023, my lord.
I am asking, do you have any objection?
My lord, the Odia University was the first language university of the state. And it was established.
Sir,
No, man, so,
of your shortcoming.
so far as the Odia University is concerned, my lord, here,
Various posts of a professors.
my lord, here the,
This last 2-3 years.
no, not last 2-3 years.
In days that
But here,
since its beginning,
let me just clarify. For the appointing authority of the professors is the Vice Chancellor. In 2025, they made a notification with respect to appointment of the Vice Chancellor. The selection process is completed. Now the names have been recommended by virtue of the recommendation through the search committee to the competent authority, that is the Chancellor, Governor, to select one name to be appointed. Now immediately thereafter, the process for appointment of the faculties will be taken up. So that process is still on, and so far as these instructions I have received.
Whether the search committee has already
Recommended the names, and that process will be completed within a week. That is what telephonic instruction I have received. I have not received any.
my lord, one thing I want to submit. It was established under the Act 2017 Act, but it started functioning with a Vice Chancellor on 5th September 2023. 5th September 2023, but they have not recruited anyone.
That is what they say, that unless the Vice Chancellor, because the statute also talks about the first statute. So it says that it is the Vice Chancellor who is the administrator, who will initiate a proceeding or initiate a recruitment process.
Yes, ma'am.
Or filling up that post. If the Vice Chancellor is not there, then who will initiate it? So only the Chancellor who can do it. Not possible to say that the process is over, search committee has already said. Done. So they will know that Say that immediately the vice chair will take initiatives to fill up the post.
Yes, and regarding filling of that post also, now the government has taken a decision to treat, so far as reservation is concerned, the entire university as a unit. Earlier it was the department as a unit. Now the decision has been taken, the entire university as a unit.
Means all the universities in the.
No, so far as this particular university is concerned, madam. And they have also taken in respect of other universities also. Now that reservation issue is also still there. So immediately after appointment of the VC, steps will be taken to fill up those posts. And
Why you have in this?
that would be much better because
The
Obliged.
May I please the lordship, my lord. My lord, petition is challenging the order dated 23/7. Item 2. My lord, petition is challenging.
This is the midst of the.
Yes, my lord.
Yes.
Millards, in fact, Millards, here,
Without the. I think you are taking an initiative.
yes, sir.
You are not doing it.
No, Millards, what happened is, Millards, it was a 2-lane road. Millard, we proposed to make it a.
That, no, I understand.
Yes.
The difficulty is, sir, not telling me, sir. There is already an entry order passed.
Yes.
That's a let it come, that will be listed and along with this.
This litigation will be treated as an appellate forum to say about the orders.
My lord, let it be listed along with this and this will be discussed on next week.
You say that both matters.
By special-
And except three
This is
sections.
a innovative, I would say, the innovative device of the legal expert to get those matters listed on the priority by finding this resolution.
This along with the, your lordship dispose of along with
This
this.
is what I expected.
Yes, my lord, that's why I'm sorry.
Expected that what is the motive?
I'm sorry.
Motive is to get those matters.
Yes,
listed as
I am submitting this, my lord. Only let it be listed along the, your lordship dispose next week, my lord.
If we encourage this, then everybody will be adopted.
No, my lord, no, my lord, this is the.
How can
You will look-
legislation be required saying that these orders, interim orders.
Because of pending, no,
I have not come across this kind of in my career over there or here.
the tender has been put, but it has been stalled because process has been stalled.
I understand, sir, but the resolution wanted.
Now, my, yeah, but we are only in respect of the shifting of the pole because the accident is every day. There is an
There is
accident.
an interim order. What-
Yes,
what-
only,
Will not.
only this will be listed along with this, your lordship.
It's the main motive of this PIL. It will be kind of a. The mention was.
I have stated like this also, because of this pendency of this repetition, the tender, because cannot be shifted. So your lordship only decides, your lordship decides
It is.
along with this. Since 1 year pending work on not being done. Because daily accident taken place. In the dark.
Only withdrawn in 2025. So petitioner can take benefit of that.
Two series.
Has the petitioner taken benefit?
Benefit.
I'm appearing for opposite party number 213.
Item 6.
Madam, short item. Short pass over. Short pass over. Oh, senior counsel is on the legs, madam.
This one. This is Tanda Bhakra Waterfall in Keonjhar. It's picnic spot for its management. So there's
Describe the petitioner.
this one.
This was the contract till 29. Why you cancelled it?
Minus he had sought his experience certificate and we had applied
I've
for the
already-
factual. We had see,
I have already experienced it. I have
So
annexed,
yet-
annexed in the.
applied for his experience certificate and we have asked for a factual report. So I have sought for that factual report from the authority in para 7 minutes. So in para 4 minutes. Page 4. After receiving the same on 24th.
Not running, my lord.
Not running
Yes,
my
yes,
collect.
Yes, yes, yes. To 2018, my lord. Yes, yes, my lord.
Let's challenge the presentation regarding the management of the
Not.
Sanabhagra waterfall.
No fault, my lord. I have. Yes, my lord. And another arbitrary guideline was there that one must. My lord.
The notice dated 20th of January, February.
My lord, may I pray one thing, my
There is a clause.
My lord, may I pray one thing, Mr. B.S. Tripathi, senior counsel, on his leg. Yes, my lord. There is a.
Tell me that particular clause.
Yes.
Of the notice or letter.
My lord. I have applied for experience certificate in Annex 2, my lord. Page, my lord, page 18.
Correct.
Yes, my lord. And annexed in the writ petition, my lord.
Page 18.
Yes, my lord.
With
Page 18 is the correspondence from the Assistant Director Tourism Keonjhar to the Sub-Collector cum Chairman Sandhagra who advertised this notice for experience. Because I am the experienced one, because I have annexed the Annexer 3 series for the period from 2015.
anyhow, they say that you sent a factual report.
Yes, so I sought for that factual report. It's not attached here, so I've sought
Then
for
what?
that factual.
I have filed one additional affidavit, my lord, in connection to that till now it was not been done,
Correct.
my lord.
Are they proceeding in the tender?
No, my lord. Till now, they have proceed for only to participate. Some persons as per instruction.
If they have updated that particular tender or whatever the inviting the application.
My lord.
So, are they proceeding with that? The applications are being received by them or what?
After Annexer 6, may kindly see, my lord. After Annexer 6 in the additional affidavit filed, my lord. Page 6. Page 4 is the modify. First they have notify, then modify. Page 4, Annexer 5, they have modified that on 12/3/2026, verification will be there. On 13th, display will be there. And on 16th, auction date and time will be there. But I have approached the authority, that is the Sub-Collector, Keonjhar cum Chairman Sandhagra Development Committee, as at Annexer 6, my lord. On 16th, my lord, I have approached and request him to defer the process of. Basing upon which they have not proceeded further. And I only
I'm seeking,
before your lordship.
I'm praying for some time now as regards the status of this experience certificate.
I have already annexed that.
What the factual report says, if court permits are also final, it will be to that extent. And it's what the factual report says and. Yes, ma'am. In that manner, it's in page 13, the particular clause which he's challenging is
Page 13.
Page 13 under eligibility criteria. Yes, ma'am. Page 13, eligibility criteria. 6th point, ma'am. A participant should present a presentation
It is open action.
as per his turn on 10th March regarding the
That is for conversation.
that he has challenged, ma'am.
This is the earlier one. Participant must obtain an
My lord.
prior to the participation.
My lord.
Yes, so,
This is we wanted to challenge that I have already applied for a certain.
yes, so the experience certificate he has not
Not given, my lord.
been given.
So,
Yes, my lord.
Yes, ma'am.
This is my given, my lord.
you are taking it for wrong clause.
No, ma'am, the second clause is also challenged by him, ma'am.
This clause, you see now.
Yes.
Oh, yes.
Madam? Yes, ma'am. Sub-collector क्यों जी? Ever, the word ever should not be used.
Yes. These finally drafted.
Bad ballots have regarding bad ballots have certain instructions as to what here a picture once I have that factual reference.
Prayer is very bad.
Prayer on the part. I should participate, my lord. I have prayed before your lordship to participate in the auction.
No, sir.
As I
I
have
said that and reading clause, which is I believe is the one of the very good clause which is.
and I will withdraw that, my lord. On my oral prayer, I will withdraw that.
They wanted that you have some innovative ideas, give a presentation so that.
I have. If your lordship, please, if your lordship
In the minute.
permit me, I will explain my.
Clauses which are absolutely.
Yes,
wrong for.
Yes,
You
ma'am.
are not challenging those clauses.
My lord, may I please, my lord? They have a committee was there. A committee was there. If they recommend someone inside them with any other so for that they have I will withdraw that particular point, my lord. Your lordship.
You have to do many things. That people withdraw will not do.
My lord, only that part I will. Your lordship. I will only to participate.
Then why the court will allow you to participate?
As per their norms and condition,
You
my
say that there is nothing, we can't allow you to speak.
lord, may
Unless
finally.
you seek, I would say the revision of some of the clauses.
No, my lord, I will on that part. Your lordship is right. I will on my oral prayer. Your lordship may kindly on my oral prayer that may be. My lord.
Impressing. This law, that same law,
Yes,
not to universe.
my lord, my lord.
It's. Okay.
Yes, my lord.
So, your prayer is not outside that.
I have only simple prayer, my lord, that I will participate in that auction. I have.
Then we are doing by a simple prayer.
Then I know, my lord. Sorry, my lord.
The court should
Sorry, my lord. Sorry.
enter into that administrative domain.
No, my sorry, your lord.
Only prayer is that to participate, allow him to.
Absolutely, my lord. I will be. Your lord, please just the contention of the. Well,
Is it similar to that?
but he's on another. Yes, my lord.
He's in this. Okay.
My lord. My lord. Your lordship, this
I will confirm. The finishing the case. Let him come.
My lord.
I'm very actually.
I. May I please your lordship? Lordship, the petitioner is a registered special.
Yes, sir.
Yes.
But MSME,
Yes, yes, your lordship.
because a lot participate, then after you become eligible and
Yes,
successful,
Yes, your lordship.
then you already say that you are entitled to
Concession.
concession deposit.
Yes, your
But
lordship.
they are insisting for the full deposit.
Yes, your lordship.
There is a clause, there is a provision under the MSME Act. Or any clause in the tender.
Your lordship may kindly look at the. Lordship may kindly look at page 43, clause 15.4, your lordship. 4. Yes, your lordship. During the time of tender, your lordship, the
And there is a provision under the MSME Act, it says that.
your lordship, it was by a memo they gave the concession to the the revised memo is here, your lordship. Sorry. Lordship, the memo, kindly have a glance at paragraph 1, your lordship. They say, it clearly states that it exempted. Yes, your lordship. But your lordship, when the tender was finalized, there was the memo, existing memo was 503, your lordship.
When they ask, when they procure the
The tender was floated, the memo in force was memo.
Sir, I am asking you a very simple thing. Please try to understand. I got your point. You are trying to say that this memo cannot be applied retrospectively. I understood the point. For that, I am asking when the tender was floated. Give me a date.
27th December 2024.
Yes, sir.
27 December
2024.
What was the last date of submission of the
20 January 2025, your lordship.
20 January.
Yes.
25.
What was the original date of the date?
Or 21st January 2025.
How can you apply this?
Yes, ma'am. This have prospective effect from 5th March
This is
onwards.
the paragraph 5 is I think paragraph 4 last line is very
Yes,
same.
from the date of issue, 5th March 2025.
2022 circular was prevalent.
The 20 come to effect after 5th March, after
Circular is prevalent.
till
This
5th
same
March.
exemption, how can you deny it now?
Yes, has come with effect from 5th March. Yes.
That is the demand.
And it's
Lately, what saying straight away. 3-4 days are relevant. Nothing more than that.
on a slide letter dated 27th February 2026, 117, annex to 6, his request was denied. Yes, and on 117, letter from Special Secretary to Government, the request was denied on the ground that the said notification of 17th January 2022 has been withdrawn. So it's no longer in existence. That is the relevant.
This office memorandum has been withdrawn.
No, the 17th January 2022 memorandum was withdrawn by way of this memorandum, 5th March 2025.
So what verification? I think it is a very clear cut case.
Yes, ma'am, it have prospective effect from March onwards.
You are challenging 116.
Yes, your lordship. Yes, your lordship.
No, after this 5/3/2025, there appears to be a several other office memorandum. Is there any other office memorandum?
This is the one. Because,
This is the final one.
yes, ma'am, because 17th March 2022 during COVID that was issued.
Yes, your lordship. Emission certificate is here, right? I have it here, your lordship. I haven't annexed it.
In both of the hearing, several documents is sought to be relied upon. Item 8.
Right, please, Your Lordship, sir. Your Lordship, in this instant matter, I'm appealing. Yes, sir.
If I look at the consent of contract, have you initiated the proceedings for that?
No, my lords. No, my lords. Milord,
How you have acted the consent?
my lord, sir, the previous Milord contract that is ending, my lords, if my lords will see, that is ending on 31st of March 2026 at page 80. My lords, may kindly see. Yes, my lords. Yes, ma'am. Yes, ma'am. But page 80, my lords, the term of the contract is up to 31st March 2026. Yes, ma'am. And now, my lords, the new 31st 2026, my lords. And now, my lord, at page 36, my lords,
What is the difficulty?
Yes, Your Lordship. Your Lordship, the difficulty.
That is for a period of 1 year.
Your Lordship.
You cannot, the contract is not going to expire to the. That is where is the difficulty?
Yes, Your Lordship. The difficulty is, Your Lordship, in Annexure 3, the opposite party have clearly mentioned a quantity that they would be requiring from us. And the quantity is 3,28,600
Quantity is given, it is supplied within
within a period of 1 year. No, Your Lordship.
If you are at fault, then.
No, Your Lordship. So the contract specifically mentioned that as and when the opposite party required the quantity, that amount of quantity will be supplied. It has been mentioned.
Go for a compensation against them, but you can't stand in the way. If they have not issued an order, they will not procure those quantities from you. And then you have quoted considering that you have to supply this much of quantity. You can go for the damages or something. You can't stand in the way of fresh tender when your agreement is expired. It's a tenure-based agreement.
Indeed,
So how can you stand in the way?
Because, Your Lordship, there is a legitimate expectation.
The legitimate expectation does not mean the extension of a contract eternal. If the contract specifically provides a tenure, once the tenure comes to an end, nothing. If anything has been done attributable to their negligence, you can click the damages or not.
Your Lordship, can I just make one humble submission? Your Lordship, the quantity that they have issued this year for the tender is almost the same quantity that is left approximately. Yes, Your Lordship. Yes, Your Lordship.
Not on a quantity basis, it should be on a tenure basis. If the tenure of the contract is coming to an end.
They were splitting.
Yes, Your Lordship.
They can neither underfill nor overfill. So what is the optimum for the survival of those animals they have to procure? And this drug, it has a shelf life. It's a perishable in nature. They can't stock it. That is supply or stock it. It requires a fresh supply.
Yes, Your
If
Lordship.
the need or the demand is less, how can you compel them? They were anticipating that this much may be required. You can't. Tenure base is there. So, you participate, they will know.
Your Lordship, we have participated.
They will take care of that.
my lords.
Your Lordship, can there be an observation in the order for taking care of us in the next?
One line, we cross there. Page 11.
Yes, Your Lordship.
Judgment.
Yes, Your Lordship.
Misunderstood the judgment. Yes. What is the matter?
Well, the substratum of this matter is a tender issued by the government, Odisha Construction Corporation Limited, for construction of in-stream storage at HON'BLE across River Telling district of Bolangir, my lords. My lords, if I may just come to page number
Your bid has been your bid has been rejected as non-responsive at the technical bid stage. At the technical bid stage,
I beg your pardon, lordships.
your bid has been rejected as non-responsive at the technical bid stage.
My lords, indeed, my lords.
Where is that order dated 19/2/2026?
My lords, page number 2324.
Page number
2324, my lords.
Where is the 2330?
24 internal page, my lords.
Have you got the copy? No. Huh? Wait. 2000 something page.
Learned colleague. To assess lordships.
Volume 2 or 3?
518% for Theta.
What is the annexure?
How many volumes you have filed, sir?
Annex 8, my lords.
Mr. Ponda,
Anyhow.
what is the volume number?
You have not.
Number is
Oh,
7.
7. हाँ, seventh volume बाहर करो.
7 volume.
हाँ. We have it. We have. এটা আরো কিছু না এইথরে বাহার কোন থেকে মিস্টার মিহির
Page 2324.
2324.
24, my lords.
Yes.
My lords, out of the 14 bidders, 12 have been thrown out at the stroke of one sword.
What is your serial number?
My lords, I'm at 4, serial number 4, my lords.
4.
I'm
Your
at
serial number 4?
serial number 4, Konkan Railway Corporation Limited.
Yes.
Maybe I'm a lead member. I'm a PSU, my lords.
After technical evaluation, such as 2 bidders are found. Oh, apart from 2, all have been rejected.
All 12 have been thrown out at the stroke of one sword, my lords.
Means 6 and 8 have been found. Why non-responsive? Any reason has been given?
My lords, that is where we come to the interesting part, my lords. If I may just flip over to the next page, my lords, 2325. Annexure 9.
Yes.
My lords, I give a representation. I'll just skim through the representation for resistance of lordships. It's dated 21st February 2026. My lords, I'll skip the first para. I'll come to the second para.
Anyhow, it says you have said that you are unable to find out the reason. And then you say the order of transparency and fairness requires that you should be provided a reason. Then what happened?
I'm grateful, my lords. My lords, then I get a response on 5th of March 2026. On the next page.
You are not satisfying the criteria stipulated under, say, clause 16.5.
My lords.
So where is the clause 16.5?
My lords, then clause 16.5, my lords, we'll have to come to page 75, my lords, volume 1.
Yes. Page
75.
Page 75, my lords. Internal page 75.
75 or 275?
75, my lords.
Yes.
My lords, to qualify of a border work, each bidder who meets the minimum qualification criteria will be qualified only if their available bid capacity is more than amount put to tender of the work. The available bid capacity will be calculated as under, they give the formula. And then, my lords, and the bold letters, the value of existing commitment should be given in the shape of an affidavit before the executive engineer notary mentioning the name of the work. If the bidder fails to permit the existing commitment in scribed format in shape of an affidavit, his or her bid shall be rejected. Each page affidavit and annexure shall be signed by the executive magistrate notary, following which the bid shall be rejected.
Correct.
Technical bid shall be scrutinized in accordance with the conditions stipulated in the bid document, my lords. My lords, if I may just come to the response, my lords, where is my grievance lies, my lords? They say that
They have already identified a formula. The formula provides for a maximum value of the turnover, then the number of the years, and then everything is to be done. Existing has to be.
My lords, in compliance of of this clause, I have already submitted my form for MEF, my lords.
No. Where is that? They say that whatever you have submitted does not appear to be true.
My lords, that is what the problem is.
Where is your calculation on the basis of this formula that you meet the requirement? What is the total value of the contract?
My lords, if I may just...
What is the...
my lords, page number 884, my lords. There is a CA report I have attached along with my...
I know, I am asking what is the value of the tender.
My lords,
it must exceed the value of the tender.
My lords, 553 crores is the value of the tender.
553 crores.
3 crores.
Okay. And according to the formula, what is your
I satisfy
bid capacity?
My lords.
What is your bid capacity?
My lords, my bid capacity is 22007 crores, my lords, as per the CA report at page 884.
Is more than 2,000.
My lords.
Yes. You have to justify.
I'll justify, but my documents are not even in volumes. It's difficult to run through all the documents. It's 2,000 pages. Lots of me write me time till next week so that I can go.
When is the date of submission or the date of opening? I mean, the opening of the financial bid is done.
Opening of the financial bid, my lords, the very next day they do it.
They have done it.
They have.
What is the date? What is the date of financial?
20th in the February.
So what you were doing for 1 month?
My lords, I get my response only on 5th of March, my lords. That is my difficulty. I write them very next day, my lords. I have written it to them. My representation, my lords, is of 21st February.
They have arranged private respondent, OP number 5. I think whether the bid has been finalized in favor of OP number 5.
Serve the notice on OP number 5. Give requisites today itself. You are keeping this matter in the next week.
My lords.
Are they appearing for 2 also, Mr. Das?
It has already been done. You can't stand in the way.
With OP 5, they have arranged.
Appearing for 2. Are you appearing for 2?
I'm for one. I'm for OP number 1.
None others.
File the requisite notice upon all. Rest. 1 is appearing. You give requisites today itself. File.
2 days. The voluminous document, that's why.
So why are you delaying then?
No, not delaying.
Now it's all is to be done in a electronic mode. Everything is to be done.
Voluminous document, that I pray for 2 days.
Mr. Ponda, after filing this,
2 weeks. 2 days, 2 weeks.
Whatever documents you are relying on, you have to pull out separately one. That will be easier for us to.
Yes, call the next.
Petitioner has been deprived of participating in the tender process. My lordship come to page 61. Page 61 only the registration has been rejected. Lordship see that is the online
License has not been uploaded for authentication. So
for registration due to license has not been uploaded for the authentication. Lordship see thereafter he has uploaded page 56. There is a checklist. Only the your lordship see that is the 14. That is the plot 50. Only the under the labor license has to be uploaded and undertaking is given, and it is not mandatory as per the clause 50, that is 510, your lordship come to page 26, it is 26, page 26, page 26, page 28, page 28, 510, clause number 5.10, your lordship see, a bidder having no prior experience of handling operation as detailed at clause 5.2 may submit the tender without copies of labor license, EPF, ESI code number. In such case, if the bidder is found successful after opening of the financial bid, he or she shall be allowed.
So so at the time of participation, it is not mandatory.
Yes.
But at the time of execution of an agreement,
Yes.
if he is successful, then it is mandatory.
But in the initial stage, after.
Oh, sir, that is your condition.
Yes, ma'am.
Yes, that is what is apparent, sir.
State Civil Supplies Corporation, notice of this. 2, 3.
Notice. What is this?
It has been open on financial bid
Has not been.
No.
Then this is a fit case for an interview.
2, 3, 4, 5. Notice.
But the petitioner has Just you write, no, say on instruction that though the financial bid is open, but the contract has not been awarded.
Apply. Last represent matters directly to give a written notice submission regarding the concept and all the things. Giving those.
Yes. Yes.
I've given this matter theoretic query on the point I have given that the regulation of PIL and the field it governs and all those things. Following the decision of the Honorable
I could not get what you are saying.
Last occasion matter directed to file a
No, what written notes of submission? Is a small case.
That's why you will, because of you will want that small case for that. Was I have cited the option?
I have not said that you file your written notes of submission.
That's orally stated that we form different details report that.
Why you're not completely, you are completing the work of the national highway?
Your Lordship's order dated 34/2025. Your Lordship may kindly see that order.
They are actually
34/2025.
Yes. Where is Justice P. N. Bhagwati's judgment?
judgment. All the judgments are there. If you will say, I'll go. I am very jealous. I'll give a set will get it. I got it, I'm not stating. Keep a set and you will give you. I'm very jealous. I did condition.
Yes, you have done a research. Let us go through it.
Because of minor, the blessings of minors. Because
Let us ponder upon the issues. We are keeping this matter after 2 weeks. We are in the midst. That's a nice accumulation of the process. We'll consider it.
When I get blessings of my Lord.
Not. Thank you. He has done a good research work.
And I have also got all those judgments. She will say that I'll.
Give a compilation and give it to. Make a compilation and give it to.
As per the list, and I'll go with all of them.
Please make a compilation of those judgments and give it. Give it. 2 weeks. They're written.
Systematically, I'll give all.
Whatever the judgments are, want to rely upon, please make a compilation of those in a spiral binding and give it to us. Whether it is there or not there, you just give.
All of it.
Yes, please give.
Well, we have already filed our affidavit, but it has not come on record, Mullahs. I'm giving the hard copies, Mullahs.
I will serve the copy on him.
So I think that
I have received the copy of the counter.
It's not a counter, it's a public interest litigation. This question of counter does not arise in public interest. It's an affidavit showing that what they have done. Give him a copy.
I have a copy on this.
The state.
If any construction, that will be subject to result of the litigation.
Just go through it. Call the next.
We have received the affidavit.
Recently, I think
Yes.
they want to need some time to file it.
You have been served?
Yes, please.
That's the 15th. Yes.
Yes, ma'am. My lord, in this case, my lord directed to provide the copies where the acknowledgement has been submitted to the opposite parties. I have submitted all the documents where the documents have been solved, representation have been solved.
No synopsis.
Yes, sir.
Is there a relation to a paddy procurement?
My lord. They have opened the Mundi, but Mundi has not been made operational. They are directing the farmers to carry the paddy direct to the miller and to bear the expenses to our tractor and the jute bags. decide that 5 to 6 kilograms of paddy are being deducted from the farmers.
What is this?
That's otherwise often is. That's a sort of as to often is. Mr. Sudhir Parekh, the senior counsel is in. Can I conduct my lord?
You want to?
That is all. I thought that you are talking about your senior is a deputy.
That's a sort of as to often instruction. See that tender price. Tender matter. Examiner has got one order from the opposite part number 5 in this case, and during that time that was COVID, and the mother of the petitioner as well as himself were under hospital. That is why they could not deposit the money in time, and thereafter they. That is agreement money, I know.
The petitioner was declared as the successful bidder. The intimation was issued to him for deposit of that security amount. Security amount. Bank guarantee form they can submit, but the acceptance form he did not accept. He did not deposit and took the plea that COVID continuing, his mother is ill, and the tender was of the year 2020. Now 5 years have already passed and it has been cancelled. That is what the
no. Yes, that has been cancelled. We have met with the. I have to get a regional opportunity to present my case before the opposite party number 2.
What does it do? You present your case before her. You do here. What rights will be?
And we have submitted a lot of series of repetitions.
Restitution is a difference in your right. What right has been
only because the tender has not yet been cancelled, and we are submitting a. I may kindly answer.
Process of verification.
It entirely depends upon the mercy of because we have already.
I have received in the slip of instruction and put in by affidavit because the voluminous instruction which I will see. Yes, that notice is there. In the safe of PWC. Madam. The page which I have folded, that is the notice. Cancellation of bid. Discuss now
They have already cancelled this.
That has not been rendered, and we have deposited the money because we will.
How you will get a advantage?
This was the missing situation. And the condition was very serious. Both the father and the mother, as well as the mother and as well as the petitioner. This has not been a re-tendered mind.
You were sitting tight, 2025, the repetition is filed.
This has not been a re-tendered.
The tender was floated way back in 2020. What more?
The other has been re-tendered.
Maybe, sir, you may be there in the hospital for a period of, say, 15 days or a 1 month or so. But thereafter, what you did?
We submitted a repentation and a meeting with the opposite party of
Why you did not approve the body immediately?
We have
You waited till 45.
we have ventilated our grievances. And only opportunity to be only we have to appear any conditions. Any conditions, okay, because the money has been deposited.
Still, claim is sought to be resurrected by filing the
But on
Item 18 is equal to 19.
made the motion. Seven Lordship, that is at running page 34 Lordship. Lordship come to para 3 of the Lordship. Only I'm on that Lordship, para 3. Page 35 Lordship. Keeping in view evidence, Lordship. Para 3 I'm reading Lordship.
I have read the whole. Don't worry, I have memorized everything.
Lordship, I know. But keeping in view the evidence, facts on records and remarks, it is clearly established that the contractor Messrs. Laksan Associates, plot number 15, Gautam Nagar, Bhubaneswar, 75102 Odisha, has deviated from tendering conditions. This is why I'm giving emphasis on this Lordship. On tendering conditions with malafide intention, they also they followed by consequent Lordship, they have banned.
And you will ignore paragraph 1.
Yes, no, that is there, Lordship. That is there.
You ignore paragraph
No,
1.
no, Lordship.
Which is large.
Yes, no, Lordship. That is there. So, Lordship, my humble self, no, Lordship, can see the sequence of events. The opposite parties came up with the tender. Lordship, that is on at 23/10/2024, Lordship.
It is only tender conditions. And the participants, let's say, participant in tender process, lordship. And immediately, lordship, after 41 tender, they cancel the tender on the ground of the technical fault, not my fault, lordship. They have never come up with the evaluation, and the straight out they will cancel the tender. And there is no contact between the opposite parties and me, lordship. Only it is a tender condition, and they are alleging violation of tender condition, lordship. Your lordship, kindly see, please come to lordship one of the condition, which was the condition in the tender itself they are studying to. Lordship, state lordship, kindly come to page 21, lordship. Page 21. Lordship, they're saying there is a clause, lordship, there is a only undertaking, that is not a lordship requirement under law, which has been cancelled, lost its force. And lordship, kindly clause 8 says, we understand that if the
that is quoted in paragraph 4 of
grateful, lordship. So that is, lordship, if there is during tender evaluation, if lordship tender evaluation takes place, this clause comes to play. They have cancelled the tender. There is no tender evaluation, lordship. And lordship, very interestingly, what are the consequences? If it found to be true, they will forfeit the AMD amount and they will for consequence actions, lordship. Because they have not forfeited the amount. Lordship, kindly come to page 26. Because they closed the tender, because of their fault, they will also return back the EMD also. So they have not received the clause 8 also, lordship. Now, lordship, after 1 year, because the subsequent tender has been cancelled, it has come to new tender, and they have, let's say, given the tender into new tender, let's say, those who have participated. I have not participated in the subsequent tender. The tender is now in force, lordship. So now they have come up with resorting this clause, and now they are coming with this blacklisting clause, lordship, 2 years. So my humble submission, lordship, without any enabling provision.
the law.
Lordship, that is the law, lordship. I'm asking myself to
Please tell me that
lordship.
if the tender is cancelled,
Lordship. Lordship.
whatever the illegality, the forgery, the fabrication which is done by one of the tenderer or a bidder will get absolutely effaced, no action, nothing can be done, and it gets all cured.
That,
No action can
lordship,
be
that could have been done on evaluation. That could have been done during life of the tender.
A judgment on that score. I will be with you if you can show us a judgment, because
There are many judgments,
this
lordship.
document to be submitted.
Forged document, that is never a forged document, lordship. Lordship, can you see the language they use?
Paragraph 1.
Lordship, the wrong document.
Paragraph 1 is very alarming.
A
Sir.
wrong document has been uploaded.
No, sir.
Lordship, kindly read. Lordship, read.
But there are two aspects.
Lordship.
Two documents have been disputed. One is the certificate,
Lordship.
another is the purchase order.
Lordship.
Both they manufactured, the authority who issued himself said that I have never issued this a manufactured document.
They have cancelled the tender, lordship. They have not evaluated.
Asking law that if the authority cancelled the tender, then this forgery, this kind of a thing will get obliterated, no action can be.
That I am so, lordship.
So one judgment if you can show, I will be happy. No problem, sir. It is for a blacklisting, sir. It is not for any other purpose.
Grateful, lordship. I am on that, lordship.
Show me a-
Grateful, lordship. Just I am asking myself a question. Under which law they will blacklist, lordship?
I just wanted to know
There must
that
be some.
which law prevents,
Lordship.
it cannot. You say under which law it can be done.
Lordship.
I am asking that which law prevents from doing it.
The authority, lordship, they lacks competency. Once they have cancelled, lordship, they have not, lordship, kindly see. 1 second.
Then we are saying that how.
1 second, lordship, kindly see. Lordship, kindly see clause 8, 1 second, lordship. Clause 8, lordship. Lordship, clause 8, lordship, kindly for a moment, lordship. Lordship.
I have seen that is quoted. That's a,
No, lordship.
They want that all the documents be genuine one. If there is any false or a manufactured or a false document,
Lordship.
the action will be taken not only for forfeiture, but
That's
also for blacklisting for 2 years.
Lordship.
They have chosen to adopt one.
No, lordship, they have closed down. They have, once they have refunded, lordship.
There are two consequences there.
But-
One is the forfeiture of the security or whatever the amount. And second one is the blacklisting for 2 years. They have chosen only one.
No, I am not. I am not on the lordship. Lordship, the language they have employed, lordship. During evaluation of tenders, they have not evaluated from where they get it, lordship. Lordship, can you again 1 second of cost of repair lordship. Understand, if the contractors, the contents of the certificates submitted by us are found to be false or false at any time during process of tender evaluation, there is no evaluation. Once it is not evaluated,
Evaluation process.
lordship,
What is the meaning of the word evaluation of the?
lordship, the tender consistent, lordship, the technical evaluation and lordship, financial evaluation.
Is it only the 2 stages or is scrutiny before the technical is evaluated?
If tender is alive,
What an evaluation
if the
process.
lordship, if the tender is alive, then I don't have any case, lordship. The tender then cancelled.
The data was alive before they could ascertain how they approached the authorities and wanted.
No, lordship, kindly see the show cause notice when they issued. Lordship, kindly see, that is the crux of the matter. Lordship, kindly see running page.
Cannot be.
Lordship, I'll show the judgment, sir. Lordship, kindly,
These are the very.
lordship, please kindly come to Annexure 5.
Mr. Doloi, we are before the court of law. We understand. Your contention is very clear.
Yeah.
Your contention is that it is only at the evaluation stage the authorities will go into the niceties, the genuinity, the authenticity of the documents and not before it. According to you, the tender was immediately cancelled before it reaches the stage of evaluation, and therefore this action cannot be taken. I understood the fact, show in the law, that the moment they cancel, everything will be diluted, nothing can be done.
That is the lordship. Lordship.
Judgment.
Then lordship,
That's the Lord. Show me a judgment.
I'll show you. Lordship, let it be.
Blacklisting on this ground will not be there.
Lordship, I'll show the lordship.
Unnecessarily, why you argue? You just give me a law.
I'll do lordship.
Give me a law.
Let him next lordship. One captain.
Any day, which day do you prefer? Tell me.
Lordship.
I'm open.
Lordship, 7th lordship.
Yes?
Tender to lordship.
Tender, it is complete.
8.
I just wanted to know the law. He is not concerned with the contract. He is not concerned with its blacklisting.
Lordship, let it become 8 lordship.
8.
8.
What time?
Lordship, fix. 2 o'clock lordship, I better.
No.
Cigarette for me.
Yes. It's fun. If you show me that.
There are number of judgments, lordship.
Yes. Tell me, sir. Tell me, sir, when the royalty can be imposed under the MMDR Act and the rules? The mining officer is here.
Sir, namaskar, sir.
Yes. Tell me, sir, when the royalty can be imposed?
Sir, after deposit of royalty, transit pass can be issued, sir.
No, when the royalty can be imposed, it is at the time of removal or without removal?
No, sir, after registration query, after clearance of all payments.
I am just asking you, you are making a demand under the law when the royalty is attracted. It is at the time of removal, they cannot remove without paying the royalty, or at any point of time you can impose royalty. What is the law?
Sir, royalty we are taking, sir, for extraction of minerals, sir.
And is it provided in the law? Tell me, sir. Which provision of the MMDR Act or Odisha Minor Mineral Concession Rules provide? Tell me. We are not aware of this. Please tell us. Which provision of law is applicable, sir?
Sir, rule 25, sir.
Yes, 25. Show us, sir. Minor mineral rules, 2016.
Sir.
Yes, sir. Yes, sir. Tell me, sir. Tell me, sir, when? Sir, tell me. Sub-rule 4.
Yeah. Sir, 25 sub-rule 2, sir.
Yes, 25. Sub-rule 4. Tell me.
If holder of prospecting license for mining lease or mining lease shall pay to the state government every year.
No. Becomes liable for payment of liability royalty, sir.
Sir, sub-rule 2 is something different. Liability is under sub-rule 4. The event.
What is the event?
When?
Tell us, sir, sub-rule 4. Read that.
Sir, sub-rule 4 where the leaseholder of prospecting license, mining lease or mining lease becomes liable for.
Becomes liable. So, when he will become liable?
Removed or consumed by him is managed.
So, is it a removal or consumption? Tell me, sir. Consumed is captive mine. If we consumed, I can understand. Removed from the lease area or
lease area, sir, from the lease area, sir.
Does it attract royalty? Tell me, sir.
Mere extraction will attract royalty. Liability. Liability is on extraction or removal.
Removal, sir.
Then, has he removed?
They are still.
He has not removed.
As per record, sir, officer record, sir, no transit pass has been issued in.
Sir, officer, can you go beyond the law? Are you not guided by the law? Ask him in Uriya, I think he will better understand.
Sir, liability determine न करिकरी आपण केमती करिवे डिमांड केमती रेज करिवे
सर एक्चुअली सर
लायबिलिटी आसिलानी कि से लोकर लायबिलिटी आसिले आपण डिटरमाइन करिवे ना लायबिलिटी आसिया पूर्व डिटरमाइन करिकि त डिमांड रेज करिवे
सर एक्चुअली फास्ट डिमांड आमे कला पर
सर प्रथमे कोंतु उत्तर दियंतु जो प्रश्न पचरा होची तार उत्तरटा दियंतु लायबिलिटी पूर्व आपण डिमांड रेज करिवे ना लायबिलिटी आसिला पर डिटरमाइन करिकि आपण डिमांड रेज करिवे कोन स्टेज रे करिवे सेटा कोंतु
सर आमे फास्ट एमजी के अनुसार आमे डिमांड करू सर तापर से ऑपरेशन करूची
सेटा लॉ की को लॉ रे लिखा है सेटा लॉ टा पढ़ी के हमहु कोंतु सब रूल 4 आपण कहले सब रूल 4 रे से कथाटा लिखा नाही
सर से पैसा डिपोजिट न कले ट्रांजिट पास भी बाहरी बनी
सर हमें जानि ना हो लॉ बियॉन्ड आपण जिबे ना लॉ भीतर करिवे
No, law that a deputy director will say or a director will say or the law will say. He is a deputy director, as said.
आपण आईन भीतर काम करिवे ना आईन बाहर को जाई की काम करिवे
Sir, as
ଆଇନରେ
per law,
କୋଉ ଜାଗାରେ ଲେଖା ଅଛି ଆପଣ କୁହନ୍ତୁ ଯେ ବିନା ଲାଇବିଲିଟିରେ ଆପଣ ତାକୁ ଡିମାଣ୍ଡ କରିକିରି ତାଠୁ ଡିପୋଜିଟ ରଖିଲା ପରେ ଆପଣ ଟ୍ରାନଜିଟ ପାସ୍ ଇସ୍ୟୁ କରିବେ କି ଯାହା କରିବେ କୋଉଠି ଲେଖା ହେଇଛି? ଚାର୍ଜିଂ ସେକ୍ସନ ଟା ନଥାଇକିରି ଚାର୍ଜିଂ ପ୍ରୋଭିଜନ ଟା ନ ଦେଖିକିରି ଆପଣ କଣ କରିବେ କି ଡିମାଣ୍ଡ ଟା ରେଜ କରିବେ କି? କୋଉ ଷ୍ଟେଜରେ କରିବେ ସେଟା କୁହନ୍ତୁ।
sir, ଆମେ MG କୁ ଫିକ୍ସ ହେଲା ପରେ sir ସେଟା
ସାର୍
demand
ସେଟା କୋଉଠି ଲେଖା ହେଇଛି ସାର୍ କୁହନ୍ତୁ କୋଉ ଆଇନରେ ଲେଖା ହେଇଛି କେତେ ନମ୍ବର ଆଇନରେ ଅଛି? ଆପଣ ଜଣେ ଷ୍ଟାଚ୍ୟୁଟରୀ ଅଥରିଟି ଆଇନ ଅନୁସାରେ କରିବେ ନା ଆଇନ ବହିର୍ଭୂତ କାମ କରିବେ?
sir,
କେତେ ନମ୍ବର ଆଇନଟା ଦେଖିକିରି ଆପଣ ଏ ଡିମାଣ୍ଡଟା କରୁଛନ୍ତି କହୁନାହାନ୍ତି? କେତେ ନମ୍ବର ରୁଲ୍ସଟା ଦେଖିକିରି କରିଛନ୍ତି ଏ ଡିମାଣ୍ଡଟା? ତାମାନେ ଆପଣ ଦେଖିକିରି କରିନାହାନ୍ତି ଏଗୁଡା?
And what the deputy director or director says you are doing.
ଆପଣ କିଏ କହିଲେ ଏଇଟା କରିବା ପାଇଁ? ଆପଣ କାହା ଇନଷ୍ଟ୍ରକ୍ସନରେ କରିଛନ୍ତି ଏ ଡିମାଣ୍ଡଟା ନା ନିଜେ ବୁଦ୍ଧି ଆପ୍ଲାଏ କରିକି କରିଛନ୍ତି?
sir actually ମୁଁ ଏଠି ଏବେ ଜଏନ୍ କରିଛି sir, ମୁଁ କେସ୍ ଡିଟେଲ ଷ୍ଟଡି ହେଇପାରିନି sir, ନୂଆରେ ଜଏନ୍ ହେଇଥିଲି sir ମୁଁ।
ନୂଆରେ ଜଏନ୍ ହେଇଛନ୍ତି?
Predecessor.
ଆଜ୍ଞା।
His predecessor had prepared the demand.
So he must be preparing similar demands also. He must be preparing for similar demands also in 2026. If predecessor has done this, he being successor, he must be following the same principle. So without looking to the statute book, is he preparing that? Ms. Das? He may be he might have joined today. So he must be aware of law, what his predecessor has done.
And madam, he is also an adjudicator.
Yes.
There are
Sir,
many things he adjudicates. If he does not know the law, how he will adjudicate? Then we have the impression that the peoples of the state are in a very, I would say, I have a very bad words for that, but I am finding a milder word for it.
Sir, rule 26, 4 and 5 sir.
Rule
26, 4 and 5 subsection.
24 and 5.
26, 4 and 5.
26, 4 and 5. Yes, 26 for advance dead rent. Dead rent can be charged by you beforehand, no problem, sir. We are concerned with the royalty.
Also 3 sir.
3. Yes.
That is also dead.
That is also says an account of a royalty by the lessee shall be kept by the deputy director or a mining officer, and as soon as the royalty payable by him becomes equal to or excess of a dead rent, he shall remove the specified minor minerals only after payment of royalty. No, I have no confusion. You will not permit to remove unless he pays royalty. But when the royalty becomes payable, only at the time of removal, if he says, I want to remove this much of the minor minerals, then you'll have to say that you pay a royalty on that, and then it becomes payable. Removal.
What suboption is
Sub-rule 6 টা কোন বলছে? The leases shall pay an amount of no permission for removal of will be issued unless the government dues in respect of the lease area are paid. The government dues not paid ହେଲା ଯାଏ ତ permission ଦେଇ royalty dead rate sufficient ଏଗୁଡା ତ government due ଗୁଡା ତ ସେଥିପାଇଁ due ଆମେ demand କରୁ। Rule 26(5) sub-rule 5 of rule 26.
Either royalty.
The fact is that we have paid royalty in advance at the time of for 1 year at the time of execution of the lease deed.
On what basis?
On the basis of the minimum guaranteed quantity bills. That for 1 year we have paid deposited and we have obtained receipt bill. Thereafter, due to their negligence or fault in granting the order that is clearances, COT, so CTO, we could not operate the quarry. In the meantime, 2.5 years have been elapsed. Now he is demanding for that 2 years to pay royalty, then only your.
So, but there was no incident of removal.
No, till date we are unable to operate because we have.
Because under the law, he can ask for a dead rent, he can ask for a surface rent, whatever.
Yes,
everything he can ask for.
Miller.
But
he is referring
No, he must
Miller.
no, what, Mr. Bhiyan, what we perceive from his tenor of approach, I may say, that you ask for, you have extracted,
No,
you
we could operate.
operate. Achha. What his perception is that you have asked for transit pass. At the time of issuing this transit pass, unless you deposit this,
Absolutely.
you cannot issue the transit pass in pursuance of this rule 26.
That is the wrong rule he is referring me. That is for prospective license bill.
Yes.
Rule 32 is the irreversible chapter. It will be presently it is governed under chapter 4 Miller. That is for co-release of minor mineral. 32. The language is same Miller. Kindly turn.
Yes, liability.
Miller. There the language is also same. So that is for prospective license and specified minerals. Here is for minor minerals for co-release, like that of the petition. Sand soil.
Conditions of release.
yes, 32 is in relation to a query.
Yes,
Yes, query leases.
Yes.
And 25 is in relation to
Prospective license or a specified minerals.
specified minerals.
Right.
So it's not there. It is 32 will come.
Only 32 is the upper.
Yes, the second proviso.
Yes, Miller. Your Lordship may kindly see, your Lordship has already determined, Miller. One says all leases for minor minerals other than specified minor minerals shall be liable to pay royalty or dead rent, surface rent, additional charge, etc., etc. Provided, your Lordship, subsection 2, the second provision.
No, I read it. That's why I'm saying.
Yes, your Lordship has already determined in one of the cases that royalty is only chargeable either if the minor minerals is consumed or removed. That is also the language used in the
Consumed means, as my lord has said, it is captive.
Yes.
Captive use.
Yes.
Then only it can be consumed.
Right.
So,
without issuance of consent to operate and other necessary formalities, now you are demanding that for 2 years you pay royalty MG Group again. That is in our grievance before.
Madam, it can't be. Sorry, it can't. And he is confused between the provision related to specified minor mineral and a quarry leases. Just imagine, if he is a person who has been entrusted with the authority, grappled with the applicability of the provision of law, I think it's a high time the government should ponder upon the issues. It's a high time. Either some orientation program or any kind of a program should be done.
He is mining officer.
Oh, finding out.
Both, whatever. Just imagine, doesn't know which provision is applicable to specified minor minerals, which provision is applicable to other than specified minor mineral, which provision relates to our sand queries or queries. It doesn't know. Citing a wrong provision.
Advanced.
Chapter 4 is a relation to grant of query basis.
And 25 also you see had not
Well, it's
heading this rule 25
Yes.
which he has shown
so it is specified minor minerals.
that itself.
It is sand is a specified minor minerals. Then
No, that to sub rule 1 that correlates to sub rule 4. So sub rule 1 is prospecting license come mining lease
Yes.
or a mining lease shall be liable to pay. So that relates to mining leases
Mining
and
leases.
prospecting.
Yes, ma'am. This is post.
So it has nothing to do with chapter 4.
That also comes under chapter 3.
So,
15 to.
so you take classes now for the officers. Of course, you have to.
That's may I mention 33(2). 33(2) of the Act.
The rules.
The rules, sorry, rules.
So if he is in so nascent stage, how is he managing the affairs there?
And it's
Madam, that is a different issue. That is a different in. What are you talking about?
I presented the section with a little doubt in my mind.
Madam, you come to 32(4).
32.
So very clear.
Yes, and also,
Read
madam,
it.
so
Read
also,
it. The quantity of extraction beyond the minimum guaranteed quantity may be removed from the lease area only after payment of royalty, additional charge, amount of contribution payment to DMF, so and so, so.
And in the incident, if the incident of removal has not happened, can it be charged as a royalty? So that is what is there. It may be that minimum guaranteed the quantity which is there. They can say that this is what the royalty would come because the rate has already been specified. Everybody knows out the specified rate. They have to pay. And then it comes that if they want to give extra taxes, then they can also do it upon payment of royalty. But royalty, when minimum guaranteed, they have to remove. If they do not remove, that may invite the other consequences to follow if they do not do it. Minimum guaranteed. The consequences are there.
Also, may kindly see 32(3) also. 32(3). In addition to the surface rate, dead rent or royalty, as the case may be, the lessee shall be liable to.
Additional charge, amount of contribution towards the DMF and also EMF. That is what is the obligation. There is no doubt about it.
Even
And
if
Mr. Bhia is also not, he is very candid in his approach, saying that no, he is liable to pay that, but not the royalty. From the very beginning, he has made it very clear.
He is liable to pay all other components except the royalty. because he has not removed.
Yes.
So brother, I don't think so. I have already dictated one judgment. Where we are passing an order. Unnecessarily, we cannot spend time on him.
It's passed.
Sir,
I'm just
sir.
writing the case number.
26.
403 of 2026. The order has not been uploaded yet, madam. It's 403 of 2026.
What is that case number just?
403 of 2026.
Yes, yes, mention, give it to me. Yes. Yes, as well. Good to say. I know, I dictated that.
This might be CTO has to be renewed by. Otherwise, you again.
All consequences will say. Then, yes. Next.
32, sir, 32,
Already we have to transfer now, so small order will be just very constant.
Yes, call the next.
sir, rule 32, 3.
What is that, Passover? No, Passover is for the day. You continue with this.
Sir,
In 20, we are filing counter measures.
The counter affidavit is going to be copy served upon the advocate of the petition. Would you like to file rejoinder?
Item 21. 21 Muller, we have filed for affidavit yesterday Muller. We have e-filed it Muller. It is not come on record.
Give it.
But that's one thing I can point out, Lordship. Lordship can say last order. Your Lordship has paid Lordship the entire operation. Council agreed the opposite made a statement here, Lordship, that he is not executing agreement also, Lordship. But this official Lordship, they encouraged him to complete the work. Lordship, can the photograph? Today, their comments, their working Lordship on the some project.
No, we have already restrained him from proceeding any further.
That's a kind of photograph, Lordship. Please see.
Then you take out whatever, this can't be done in this, then you take out whatever you want to do.
By one affidavit.
Whatever. I do not know whether the affidavit is appropriate or not.
Yes.
There is already an entry order.
Entry order, Lordship.
You think of it, what to do.
Lordship.
If the counter affidavit service has been affected, rejoinder effect within a week. Next.
From the government making served. Yes, but I'll serve a copy. So intervene Muller. He has been intervention application.
No,
I'll serve a copy.
Serve a copy.
Yes.
That's the entry mode to continue.
Always. Yes.
22.
Petition is a diploma engineer as well as replace and repair. Petition is granted to issued by the Contractual notice in Government of Orissa, Office of the Chief Construction Engineer, Rural Welfare Sector, but on 30/11/2025, challenging and can see para 14 at page 18. Qualification criteria.
No, this is a diploma engineer and B class contractor. You are relying on a particular comparable tender where the 30% has been prescribed. That is your case.
Kindly see qualification criteria and general experience at page 18.
It says that he must have participated in a works valued at rupees 20 lakhs and 3 crores. Correct. And you must also submit the execution of the similar work up to 75%. You say that a comparable tender which is floated by the authorities, where the threshold experience is 30%. then why they are keeping a 75%? This is your case.
But the petitioner.
But it appears from your face, you are still in a dire of confusion.
The petitioner pays.
Am I correct or am I not correct?
Correct.
So why confusion? Sorry.
And this is for a moment, and this is page 18, paragraph 15, D, para D. The intending tenders should have updated GST certificate for this PAN card, no undertaking towards GST and PAN card is acceptable. Roman I. The intending tenders should have executed similar nature of work for 70% of the estimated cost for to tender during any pre-financial years taken together of the last preceding 5 years, excluding the current financial year. In case of a contractor spanning from more than one financial year, the breakup of the execution line in each of financial year should be punished. The petitioner is lesser and obtained the license B class contractor in April 2025. He has no experience about this construction of work matter. Therefore, the said clause 14D I is applied to the petitioner. The petitioner will be deprived of the said works at the threshold to the violence of the fundamental rights of Article 14 and 19 of the Constitution.
Fundamental rights.
In case of they have debarred my lord.
Sir, in every contract, an experience is one of the aspects thereof. They can't take a risk of awarding a very important contract unless a person has an experience. So I think there are multiple contracts where they do not have these kind of stringent conditions. So gradually one develops. How can this be done in this way? Is it restricted to B class contractor or?
He is not eligible as per the eligibility criteria.
He is himself admitting.
Yeah. Yes, ma'am.
I am asking you, is the B class contractor, it is restricted to them or it's an open one?
It's an open one as per the eligibility criteria. Only those who have that certain work experience, they can apply.
What is the nature of the work? What is the nature of the work? Yes?
Approach road. Construction of approach road. And minus it's open to A class and B class contractors.
No, it is open to special class, A class and B class, all. And different parameters have been given.
The minus an identical clause was challenged before this Honorable Court in Winners Pharma Cuttack versus State of Orissa, wherein that petition was dismissed. And then another petition was filed challenging that same clause. It had come before your lordships. The lordship had applied principle of comity and had upheld the judgment of the division in marriage program.
She has done groundwork.
Huh?
She has done groundwork. Same provision. Same provision.
From identicals.
What more, sir? Now we are stuck up with our own judgment. What to do, sir? Now tell me.
But identical. Minus part of it is
Sir, this clause 5.2.8 was challenged and similar one that he must have this much of work already done, must have an experience of past experience, and everything was there for 5 years. And it was held in earlier judgment, that is the winner's pharma, and it was held that no, it does not offend. So we have accepted coordinate based decision is binding on us. So we have also accepted it. Now what to do, sir? We cannot deviate. Same thing. Nothing more. Do we require any the instant repetition is Please call the next.
Bids of 11 bidders.
Just 1 minute.
Paragraph 5.
Yes, how can you adopt the lottery if he is considered to be the lowest bidder? If there is no other person who matched with his price, then how can you go for a lottery? When the lottery can be taken or done, when more than one have quoted the same price.
Yes. Bid documents that I have submitted just now, and also as for my last instruction, therein when he quoted his price, it excluded the EPF and ESI employees share, and he quoted the price after deduction of the same. But this decision was to include the same in the price, in the salary. And that is also reflected when it's in page 166 of the
Suppose if he includes the price, will it go up?
it will come as the same similar price as quoted by the others, between 20 to 21,000 as quoted by others. But he, after reducing, this amount comes from 13,000 and 12,000. But others, they had quoted without reducing the amount, which is 21,000 and 20,000. It's in 166.
Then file your affidavit. Let us consider, let them, affidavit, 2 week, 1 week, 3 weeks. Let them. Next.
Item to 22nd.
Next.
Item 24.
Yes, why you are not releasing the escalation bill?
It's 26 recently released by the price escalation has been paid, and the amount which has been withheld is 24 lakhs.
So-
There will be the price adjustment clause that was yet to be
That is where you were adjusting from the running bill. So you have to pay back,
that will be released.
which within, tell me.
If you Rogers, please, you may pass.
We are directing him to pay, we're directing you to pay within 2 weeks.
Yes.
Within 2 weeks, you get it back. The
May I please, Madam? So I, attention, my lord. Order dated 18/3/2026.
Termination of a contract means 29/12, where is that?
If my lord, I provide also attention order dated 18/3/2026, my lord. Will also directed to correct itself from central
So
government.
that is what usual order. But what is the meaning?
Annexure 5 will not be petition.
You have not deposited the license fee in.
Your Lordship, the contract has been terminated twice, Your Lordship. As per the representation given by the petitioner, it has once, again, he was given a grace period of till 21/2026, Your Lordship. Thereafter also he has failed. Thereafter, on 27/1/2026, Your Lordship, the contract.
Put on affidavits, will dispose of.
Annexure 5 will not.
Sir, put on affidavits, these are alarming. When you were given all opportunities, how
3
soon?
times, Your Lordship.
How soon?
Your Lordship, 2 weeks.
How soon? 2 weeks. 2 week, 1 week, matter to appear after 3 weeks.
The second pay.
Yes.
Return
Compensation.
Lordship, on the last occasion, we have just stuck with the issue of jurisdiction. And your Lordship was referred to judgments to go through, and I've gone through those judgments in detail, and I'm very much convinced that this Honorable Court, as well as the High Court of Delhi, has concurrent jurisdiction to adjudicate this matter. I can explain your Lordship if you just give me 2 minutes.
I think I have given you a Kusum Ingat and Alchemist, both the judgments of Justice S.B. Sinha. One.
Correct. I'm just put for. First of all, I will just dissect the Kusum Ingat judgment, Lordship. Here, this judgment clearly emphasizes the presence of even a part of the cause of action.
No problem. I am conscious. We are conscious that a minuscule part of the cause of action may create a jurisdiction.
How the judgment is applicable to the present case. Your Lordship, the entire operational backbone of the contract is rooted in Bhubaneswar. The entire workforce executing the contract was recruited, deployed, and controlled from the Bhubaneswar office. The Bhubaneswar unit is independently registered under GST, reflecting a distinct and substantial business establishment housing around odd 250 employees. All operational, administrative, manpower deployment, supervision, and logistical execution emanated from Bhubaneswar, Lordship. And the dispute arises directly out of such performance of contractual obligations. Therefore, the performance of contractual obligation is inseparably linked to this, Lordship. I feel I have satisfied this cause of action test. Coming to the second judgment, Lordship, Alchemist judgment, the judgment clearly emphasizes that the cause of action must have a direct nexus to the list and must not be illusory, Lordship. In the present case, without deployment from Bhubaneswar, the contract could not have been performed at all. And the dispute directly arises out of such performance, Lordship. Therefore, the nexus is direct.
Where was an execution of a contract?
Execution, it is executed in Delhi, Lordship, but the backbone of the contract emanates from Bhubaneswar.
Yes.
And your Lordship, the following essential facts forming the bundle of cause of action occurred within also.
Decision.
Arises in multiple jurisdictions, each High Court has concurrent jurisdiction. The existence of jurisdiction in Delhi doesn't oust the jurisdiction of this Honorable Court. Jurisdiction of one High Court.
Give me what you have a write-up, give me.
Lots.
Give me the write-up.
Fine.
And give me both the judgments.
So I have two copies of Alchemist judgment and I just have one copy of Kusumi's words.
Give me one copy, yes. Don't worry. And your writer.
Love.
It's at 26. 26 accommodation. Security printing and minting corporation of India Limited. New Delhi.
Yes.
Lordship,
Yes,
I would like
yes.
to draw kind attention to page number 5 of the Alchemist judgment. Page number 5.
We'll read it. Don't worry about it. Yes, we'll take care of that. Yes, what about you? Would you like to say on this preliminary objection?
Last second also raised this point is about the maintained road jurisdiction.
No, he is citing these two judgments. He has not taken care of the subsequent judgment based on the Kusum. He has restricted his consideration on Kusum and Alchemist, which the bench reflected. And do you have anything, you have any judgment to say on this ground, on the question of territorial jurisdiction?
I have the one decision is his favor to him. There is a the 2013 scale. This novel cut. That decision is in their favor. If any communication to that place, it will be jurisdiction basing on which they can.
What?
Novel cut one decision is there in scale 2013. That decision said, the Supreme Court said that if any communication made to a particular person in a particular place and it was delivered to him, then it is a jurisdiction basing on which they can raise the issue. But if
That was in relation to a disciplinary proceeding where the punishment otherwise communicated.
Yes.
But that is a different concept.
Commercial.
It is a commercial where the contract is there.
That decision cannot be applicable here.
That's all. We'll decide it. We'll decide. No, territorial will decide. Keep it on Monday. You will get it.
Give your results.
Yes, March.
Directed my lord, your subject partner to take
Yes, sir.
instruction. Directed my lord, 11-3 order if you are still 11-3 order.
Yes.
I'm appearing for the opposite part number 2, my lord.
So it relates to
What is the stage
some
of the
kind of a nexus to be created between clause 3.7 and 3.12.
Your lordship wanted to know what is the stage of the RFP. In one district, my lord, already.
No, it says at the very nebulous stage.
No, one district, my lord, it has already been, we have awarded the contract. And 5 other districts, my lord, this final selection process is already finalized and it has come to this stage. And 18 district, my lord, the selection process is at the final stage. And lordship, on the self-same prayer, my lord, 2 writ applications were filed. And Lawrence single judge, my lord, in both the matters are directed that the opposite party number 2 to take a decision with regard to the clauses which is under challenge for a lawsuit.
And it has gone to a single bench, then why it has come to a division bench?
Lord, already 2 orders have been passed with regard to that.
No, how can it go to a single bench? And then if it can go to a single bench, then how it come before the division bench?
I just wanted to bring to your lordship's notice because already 1 order has been passed.
What is this going on? This kind of a forum shopping is not permissible.
What are the clauses, my lord?
No, it.
I understand. Then how can
The categorization, I think, some other categorization
was not present there, my lord.
how it is happening? And those are disposed of or are pending?
They are disposed of, my lord.
One additional standing counsel for the state appeared in this case.
Why you people are not raising that it relates to a tender? Then how these are taken?
I think health or something like that.
Health Mission. National Health Mission.
Health mission. No. Categorization in this case.
Tender matter.
अपन ठीक देखो ना देखो categorization अच्छे जाना पड़ेगा. इधर नेट मरेगी. ये जो एक केस है 1280 of 2026.
They might have put a different code.
ये जाना पड़ेगा पीछे. Category
Code number they have put.
Code number, yes.
That is why.
But what is the responsibility of the state?
That
You know the subject, you know the contents. Did you not raise both?
Ordinary civil matters. That's why it has gone to
what?
Ordinary civil writ.
Ordinarily civil matters, since it is
That goes
written
to-
there, so it has gone for the thing.
So he has not.
Everything is ordinary civil.
I got to.
Can there be any special civil?
Subject matter, if you also looks at this tender. Subject matter is.
No, SR must not have pointed out that this correct classification of categorization. So it has, in usual course, has gone to.
Actually, I think SR is not equipped to go into those.
And that 2 separate bid petitions are pending before this honorable court. On the last occasion, I have submitted my writ petition, which has along with the other writ petition. And the lordship, you want to direct them to take instruction. Today, they have filed an counter affidavit, they have served upon us.
They are served?
Yes, my lord.
You have just one thing.
I'll find out.
You take up page 41.
Rejoin that.
Page 41 of the writ petition. The bid validity period was till January 2026. So now these, of course, the other 2 writs are pending discharge and that is there. But then this petitioner has approached this court in February 2026. So the bids are no longer existing. The bid has no longer, it's not been continued.
No, it was the last date of the receipt was 8 July 25.
Yes. And after that, below that, if your lordship would see, bid validity.
180 days.
180 days from the date.
Did he apply? Did he participate?
He participated.
Okay, then
His technical bid was rejected.
rejected.
And
Then he is challenging that.
He's challenging
When-
after we took a call to discharge the tender because most of the bids didn't qualify and we were also gaining some amount. So keeping all this in
So
mind.
you have already discharged the tender,
Already
not
discharged.
fresh.
Fresh tender, your lordship, in the other two matters, your lordship has stalled that. But so far as this entertaining of this writ, all that I want to say is he's coming to this court after
That is in our bench.
Your lordship.
Yes,
These stalled the fresh tender by our bench.
by this.
What is the order? Normally we don't. Oh, this is in relation to a lead member of a consortium.
Months. Other two writs are by two members of the consortium. Here, petitioner is independent. His bid was also rejected. The reason for rejecting the technical bid was that
Just.
interim order was also granted, paragraph 6.
So that is, they have raised a very pertinent questions. The validity period will not stand in the way of this matter.
That matter, there's no issue. So far as this writ petition, the day he files, it's just
already the validity period is over.
All that I wanted to draw.
Suppose there the court succeeds and then directed the opening of the financial bid. Then in that event, what will happen? The validity period gets extended.
You're not so have all the powers.
So what will happen now?
Those who have come.
So if his technical bid is also quashed, the rejection order goes, then he is entitled to offer his candidature at the financial bid stage.
In fact, if your lordship wants, I can read the larger picture. Here there were issues regarding documentation. Most of the documents came after the cutoff date. So we took a decision that let us give them a fresh chance where all these documents can come in. Now this was regarding a green tug, which is supposed to bring vessels from the sea to the Paradip port. Now
from where to where?
From the coastline to the port. So since it's a tug, so it tugs the main vessel to the port. It's a green tug project of the central government where we are not supposed to use fuel and all other renewable energies to be used. That is the case. Now, all these petitioners are participating in a similar tender for another tug. The petitioner is also there. So none of them are also prejudiced. The present petitioner is also participating in the tug. So first tug is subject matter here. We have stalled it. The second one is ongoing.
So in that matter, the affidavits are complete.
Complete.
In this also you have given.
This also given.
He wanted a time to file a rejoinder.
Rejoinder within 2 weeks.
Rejoinder. So let the rejoinder be filed.
And let its petition be tagged along with the other two writ petitions. Because the subject matter of challenge is same, my lord. Is the notice of discharge of the tender. And what my learned friend has said, my lord, I'll put it on record, my lord, that is actually incorrect and give it in my reply. In my rejoinder. My technical bid was never rejected. My lord, he should not, my lord, make incorrect submissions.
You said it is rejected at the technical and he says never rejected.
Comes to page, my lord, 216.
We didn't
no reason have been given.
We didn't find him qualified.
Yes.
Malad, I'm first practitioner, Malad, an interested in handling private limited. Admitted.
Pre-qualification, the technical.
That document, your lordship remembers that they are saying that is admitted means the date we open it. Thereafter, it goes for evaluation. So let my lordship
File a reply. The counsel for the petitioner submits that. Yes.
So there's obviously in the other matter. So it's not.
It's not, that is on a different.
and it's not a separate.
Yes.
Very grateful.
I'm grateful, Malad.
May I please inform?
Yes.
Applicable or not? I have submitted my tender in view of the notification of Office Memorandum 3/1/2026. And thereafter, a clarification was made on 9/1/2006. But the last date of submission of tender was 5/1/2026.
So how can you do it, sir? And changing the eligibility criteria?
No, that is only nothing else. Sir.
No, by clarification, what they do?
Clarification only on 9/1 says that the 3/1 notification is applicable, which tender was floated prior to 3/1 notice, not applicable. That was the clarification only 9/1. But on our book 2, the 9/1 notification is page 21. Page 21. First of all, first you are come to page 15, the 3/1 notification, then the 3/1 notification. The bid shall be finalized as per the earlier provision in Appendix IN plus 36 OPW Code Volume 2. That was the clarification. But the 3/1 office memorandum, that page 15. There. That was been that has been amended in 3/1/2026. That's the important. That was amended. Man, you are lost on page 15. Page 50. 3/1/2026 notification. The next page important, page 60.
Where is that amendment?
That is page 15. 3/1/2026. After careful observation, government has been pleased to abolish the extent provisions of threshold negative bid of 14.99% introduced in Appendix IX plus 36 OPW Code Volume 2 in the procurement of works undertaken by the government of Orissa and its agencies to ensure the procurement process results in viable to successful manner in application. That amendment shall carry from the date of application. And page 16, next page. These amendments shall take effect from the date of issue of the office memorandum. That is page para 2, page 16. And accordingly, the relevant existing codal contractual provisions stand modified with effect from this office memorandum. And taking into that provision, office memorandum, I have submitted my bid. The last date of submission bid was 5/1/2026. I have filed on 5/1. Thereafter, after submission of bid and the expiry of final date of submission, they have made a notification on 9/1 that is modifying the clarifying that the earlier notification. And my technical bid was opened. I was in serial number 2.
Lordship may kindly see annexure 2. When the notice with respect to e-procurement tender was issued, The notice was issued on 2012-2025. Annexure 2, page 9. Yes, the amendment brought to the OPWD code on 3.1 and subsequent amendment on 9.1, both are prospective, and those amendments were never incorporated by either by way of addendum or corrigendum to this tender document. So whatever conditions was provided in the tender document, his application was considered accordingly, and the persons, those who qualified in the technical bid and the financial bid, they were considered and awarded with the contract. Both the memorandum were issued subsequently, and those memorandums were it is not made retrospective. Your Lordship may kindly see, none of the memorandum was made retrospective. But the memorandum brings an amendment to the OPWD code, but it has to be incorporated by way of an addendum and corrigendum to the tender call notice. But it was never incorporated. So all the bids which were accepted by the last date were considered in terms of the terms and conditions provided in the tender call. No. That is what my instruction is.
That has been changed.
These financially, after receiving the introduction, they will have a manual budget of related from revision of the condition which is already provided in the tender document.
Yes, ma'am.
Your documents filed in accordance with this tender call notice that was considered and you were not found eligible. Or
yes.
So, yes. My response submission for honor that in view of the office memorandum, which is common effective, and that
sir, he has not taken into consideration that notification or the regulatory code as amended.
That is been stated. That is in the office memorandum that is clearly stated. Accordingly, the extent existing codal contract of business stands modified with effect on the office memorandum. That is in the office memorandum.
But tender condition is not modified.
That tender condition in view of the OPWD code, when the OPWD code modified from 3/1/2020 in view of the office memorandum. Opened my technical bidder and I have selected my serial numbers too.
Yes. So he has been qualified in the technical and financial bid both.
Only technical. Well, financial bid.
Not L1.
Financial bid is not open. Financial bid I am L1 because my rate quoted rate is 15.6. My rate quoted rate is 15.6. I am the L1 because in view of the earlier provisions, all the bidders quoted their rate less than 14.99. But my rate is 15.6. Then I am the lowest bidder. But that my bid finance was not taken into consideration in view of the subsequent modification by 9.1. That was the
financial bid was opened on 19 January 2026. Regarding that financial bid, whether it has been finalized in favor of somebody else, so that instruction is not there. So I have asked them.
Just let me understand.
Yes.
The tender was floated prior to 3rd January 2026.
Yes.
At that point of time, what was the condition?
Yes.
What was the condition?
But the-
person was scored
But that is at 50,
not below 15.1 or what?
that is
14.9.
not below 14.99. That is provided.
That was in the view of the court.
In the instruction,
More than that.
Yes.
15.3 or 6. Something.
Beyond 15. It should not go beyond 15. It should be less than 15.
Yes.
Because there.
Yes.
3.1 says that you can.
Yes.
3.1 2026 circular says that you can promote beyond 15.
Yes.
Sorry.
Yes.
9.1 clarified.
Yes. 9.1 said 3.1 is withdrawn.
No, no.
Yes.
And not with them, modified.
Whatever. So you have proceeded on the basis that neither 3.1 came into existence nor 9.1 came into existence. What was there at the date of the publication?
Yes. Yes.
That is what you
Yes.
But the last date of submission was 5.1.
Yes.
Though the tender was floated prior to that, the last date of submission of 5.1.
None of the
Yes.
conditions change.
None of the conditions.
So you have not changed the.
Yes.
In this case, I pay for an adjournment by law. 1 week after I pay.
Item 31, I mean VC, my lord, for the petitioner. This is a case of tender floated by the Cuttack Development Authority.
1 minute, I find a complaint on the product development authority. So I got some instruction, but it's not complete instruction. I tell my brother I cannot produce this or to submit on the basis of that. I request 3-4 days time so that I can get the detail and I can place it in form.
With your lordship, let me take up this matter on 18th of March. If I may just place that order, this was regarding a tender that was floated by the respondent. The initial one, I was L1. Without discharging that tender, another tender was floated. The rate that I had given for L1 stands unmatched because the difference is about 14%. There is no cancellation of the first tender process. The next one has been issued.
The first tender.
No, in the second one, I participate. The first one. No, now, your lordships have held a slightly different test to ascertain discharge of first tender also, but I'm not on that. But your lordships have, by the 18th March order, very succinctly recorded what had transpired on that day. So, I mean, I just place that, please. Let's go. Paragraph 4, last sentence, if your lordship could finally make a note of, leaves an inescapable impression that the earlier tender was abandoned and or cancelled in order to favor certain bidders who appear to be blue-eyed persons of the authority. Today in the morning, we've been favored with some documents that they want to rely on in the nature of an affidavit that they filed. I think it's called a rejoinder. A counter that they filed. And about the affidavit and opposition. An affidavit of opposition, easier.
There's been a suppression of the LOI which was issued before the writ petition was presented. The writ petition was filed on the 13th.
We have filed an affidavit on behalf of railway.
And there is a vacating that's been filed today, but it's not appearing in the list. We've again been served
We
with
are
that.
filing a counter
We've
affidavit
been served in the
mentioning
afternoon
everything,
with that.
annexing
Your Lordship, may kindly see the
everything.
prayer in the writ petition, what we have prayed for.
No, Mulot, that,
Kindly see the prayer.
that is interesting. May I just indicate? May I just finish? I'll take 5 minutes of yours.
Absolutely misleading
First-
petition has been done. Kindly see the prayer.
No, may I just? I will. I'll just face your lordships and respond to it. Instead of
Lordship sees page 29 of the.
Mulot, could I just praise? Yes, yes. Mulot,
Your Lordship,
at the stage, not 1 minute. My learned friend will give me 2 minutes. The order that your lordships have passed on 18th of March was after looking at our prayers. 2 things had weighed on this honorable court. One is the discharge of the first tender without any reason, where my bid was much lower and I was declared as the L1 bidder. The second one, which is why paragraph 4 your lordships have recorded, if I may just place once more, Milord, but the authorities for the reasons unknown proceed to float the present tender, and the recourse adopted by the tender committee leaves an inescapable impression that the earlier tender was abandoned and or cancelled in order to favor certain bidders who appear to be blue-eyed persons of the authority. Look, it's a 2-pronged attack that I have. One is what has weighed on this honorable court. First is my discharge. Once I have been given an L1 bidder, now your lordship have recently in 2024 and 2025 Supreme Court has held that I have a vested right. Because the moment you float a tender and you discharge it, the grounds of discharge is immediately open to judicial scrutiny.
but it was not
That's
exercised.
absurd.
It was never exercised.
Let him complete.
Then the Chief Justice have been there. Come on.
Let him not allow you to submit.
But one aspect.
One is there.
Earlier, 2024 is something of 2025 also. But for the sake of completeness, I'll cite it. But there's a second aspect too. When I participate in the second tender, my rejection is on the ground that I have failed to upload certain documents. Technical certificates have not been uploaded. That again, we have shown, and your lordships have recorded that we filed the affidavit showing documents were given. Then they seek time to come back. It is not submitted on that day that the LOA has been issued. And issuance of LOA also, my lord, it is not a work order that's been issued in favor of. The second aspect, my lord, now they come up and they try to improve upon what was said on that day, saying the rejection says failure to upload technical certificates, not submitted. Now they say have submitted, but one document I have not. That's the affidavit that they come up with in court, which we are favored with today. We've submitted. So now there is a departure from the ground of rejection. Initial is failure to submit technical documents. Now they say you were required to give A, B, C, D. You've given A, B, and D. C you've not given. Prima facie to show that it is absolutely incorrect. Your lordship will allow me to rely on 2 sets, because we were favored with this today in court, the affidavit. I'll show that the document or certificate they say we've not uploaded, all of them were there.
But I can show it from their agreement that they are not.
I don't interrupt people when they are something that courtesy I will also expect to be extended to all of us.
No, please don't let him complete.
I will show that those documents were uploaded and there has been no consideration of that. And this other aspect, firstly, with regard to discharge, Lord, if I may just, so all that I was saying, Lord, with paragraph 4 and paragraph 5, which is there, where a prima facie satisfaction has been arrived at by the court, that there is
some element of favoritism which is there. And this was on 18th March. Today in court, we've been favored with these documents. But if the interim order or this undertaking would continue for some time, we'll file an affidavit in reply and come back. But just to cross that hurdle, that I'm not taking this to buy time and I have documents which I can show and dispel that they've come up with, please allow me to rely on these two sets, because I'll show the affidavit that they've come up with. Their affidavit in opposition. Affidavit in opposition. My count, I'm sorry. Paragraph 13, if your lordship could just have a look at. Of their.
You have not filed any document, you will rely on their document only.
The union has
not filed.
Yes,
we will rely on their document.
You are for whom?
I am for OP number 7.
Who is
N2.
Railway aspect.
The rail.
I am the successful test.
OP number 125.
I am the L1. LOI has been issued in my favor.
L2, I don't know how. Anyway, L1, L2, I'll deal.
He is no where, nor even nearer to L.
No.
Technically.
He is technically rejected, my lord.
He is
nowhere near to.
But in the first one, I was L1 with a bid which is 14% lesser than all of them. L2, I'll come to later.
With this. Who are the parties?
That's right. Of course. But paragraph 13, this is the affidavit that's been filed by respondent numbers 1 to 5. 13, please have a look at. That in the.
What is this given?
No, that's a bunch that I'll have to rely on.
Please share the document.
No, that's separate. They, respondent numbers 1 to 5 have today filed an affidavit in opposition.
I have been given a copy.
I'm sorry, Milord, that's the other one that we.
What amendment?
Milord, that we have taken out to amend the prayers and to incorporate a few prayers in that. Milord, I'll trouble your lordship with that later.
Don't trouble.
Very well. This I'll try and not. Please have a look at the affidavit that has been counter that's been filed by respondent number 1 to 5.
Few things I would like to point out subject to it.
We have a preliminary point.
We have a preliminary subject to my learned
To show how this process.
No, L1, L2, I'll we respond to
have a preliminary issue. We have a preliminary point. Absolutely not pure question of law.
Let me just indicate this, not considering I'm already. I've beseeched your lordship to have a look at it. I'll just show this, and if he takes the point of maintainability, I'll deal with it. Paragraph 13, if my lords could just have a look at it. That in the subject tender.
Yes.
The petitioner was declared totally non-responsive due to non-submission of mandatory technical documents, specifically those pertaining to the prescribed FST requirements for paneling materials. The rejection was strictly in accordance with the tender condition as per clause 1.1 of special technical criteria of notice inviting tender. Fire, smoke and toxicity requirements pertaining to paneling material, epoxy flooring and wash basin are mandatory required for qualifying in the technically eligible instant tender. In the instant tender, the petitioner has submitted fire, smoke and toxicity of epoxy flooring and wash basin. And not included, one second, so please. And not included the documents pertaining to paneling material, which was the basis of rejection. So they say 3 things are essential ingredients. 1 and 2 I've given. 3rd one I've not given. Now, of course, this is a major improvement from their round of rejection. I'm not sure if they can do that by way of an affidavit, but if I have to still meet the bull by its horns, please have a look at the bunch that we've just given. That bunch that I've given, we've taken the liberty. The heading starts with Zen Industries. We've taken some liberty of paginating it because this is what it was there. It might be easier for me to refer to. Paragraph, running page 5, if my lords could just have a look at. These were all the certificates that were there. Look, I am only trying to highlight why the court has come to that finding that's recorded in paragraph 4. I'll show all these certificates, including for the paneling. First, there is a 13% is bid that is completely eradicated. Then there is another one where grounds is I have failed to give technical certificates. When we challenge that, they say, no, you've given 2 out of 3. Third, I'm showing from documents. Third was very much there. L1 and L2 are in no position to discuss this with me. It's R1 to R5 who have to justify this decision today before this court. Please have a look at this, and blatant comes and tells the court, we've not given the certificates. Please have a look at 2 documents. They say that regarding empanelment, I have not given those certificates. Ex facie incorrect. Ex facie. Please have a look at running page 4 once.
See the block. The block is there.
Block is there. Test reports, Your Lordship has seen. Serial number 24. Please have a look at it, running page 5. There's some way of doing it, and then there are some ways of doing it. Please have a look at. One is, right on, this is a saying I've heard somewhere. One is to
use in different tones.
Yes, and the difference is, if I'm trying to favor.
What is the difference?
If I'm trying to
one finger towards, so others are 3 fingers.
I have to get into that later. Let me just show these 2 documents. Internal page 5. Internal page 5, serial number 24. Second column, Your Lordship will see. On aluminium shall be free from deformed coating by dropping the indenter on coating side of panel. Certificate is given, test method, pass the test. Please turn over, my lord, to page number 9, running page number 9. Which is uploaded. No, uploaded. Now, that is why Your Lordships have returned the finding in the 18th March order. Supplementary, that Your Lordships have returned that finding on 18th of March. That it's evident that I have actually uploaded those documents that are part of the supplementary. Initially, they come and say, I have not uploaded anything. When we file that supplementary and Your Lordship return that finding, looking at the supplementary, the documents are there. Then there is a slight change in stance saying 3 types are required. 2 you've given, 1 you've not. I'm showing from those documents, 1 is also there regarding that paneling. All those certificates are there. And these are page numbers, test certificates, numbers, and for respective panels. The other round of challenge which Your Lordships have very succinctly recorded in paragraph 4 and 5 was with regard to the 7-year difference. L2 from the website, corporate ministry portal, we find is incorporated in 2022. 21. And the requirement is that in this work you need 7 years of experience. That's L2. Clause 10 of GCC requires you must have, even the tender has that incorporated, that you must have 7 years. You must, in last 7 years, you must have done similar nature of work. L2, I think my learned friend appears for. That company is incorporated in 2021. L1 is an LLP formed of 2 companies with 2 individual designated partners. One of them is formed in 2025.
L1 is 2025.
L1, the company, the LLP, is formed in 2025. It has 2 ingredients, 2 companies which form the limited liability partnership. One out of them is formed in 2022. And the other, apparently, we've not been able to really look at the document. Look, I am responding to this only to show that the prima facie observation of this honorable court that's recorded on the 18th March order is not bereft of nothing. Something would have weighed on the court to have passed that. The other aspect, Manoj, Your Lordship will please see that best writer there.
So it requires or to dispel what they have said.
Which we got today. Today I was.
This can be demonstrated from these two documents.
Yes, Mundi.
So we will definitely give you an opportunity to bring those.
Please.
By way of an affidavit.
Please.
As you know, showing a document.
Correct. No, it's unfair. Absolutely.
But
That's why. Yes, it's not fair on the bench also.
To come. Now, let us see what will be the objection.
Yes, but
Mr. Roth has taken.
Yes,
which we have to.
yes, but the preliminary objection because the
No, you are not taking.
I'm also taking a preliminary objection.
To that question of law.
Yes, Father. Your question.
Prior to that, kindly see page 21.
Just a minute. Last occasion, what my learned friend said, he was not arguing the council, Mr. Misra is arguing. That's why I conceded to the extent, because I have extended that we are not effective. No, definitely we have to. That's why in the very initial stage I have said, could I file the counter explaining all the factual facts, whatever they are submitting, I think either knowingly or unknowingly they are submitting. Yes.
Because he will get an opportunity.
Yes, that's why I am telling either. Yes.
But Mr. Roth has taken a very
then
is that it is not maintainable. So it's not maintainable, then why we will enter into those?
Correct.
Yeah, exactly. Yes.
Let us see.
Let me justify my submission. Lordship could kindly turn to page 29 of the writ petition. But here, there are two submissions of the writ petition, page 29. Let us carefully read this prayer.
Yes.
Today you are challenging the L1, you are challenging the LOI, saying, making so much of so many submissions. Kindly see the prayer in the writ petition. A single prayer with regard to validity of the tender or validity of LOI or validity of any award in favor of L1 or L2, absolutely no such prayer in the writ petition.
Because they came up as if
by the date you by the time you file your writ petition, the letter of intent is already issued.
But was it communicated?
But they are on website.
That's included.
Right.
Order.
Yes, sir.
Injunction.
Yes.
That is not communicated.
I am coming.
You will not be made liable for any act done in the interim now.
Yes, sir.
Cannot be.
Okay.
The thing is that he was not aware. Now, once we disclose it.
Yes.
So only thing is whether there is any document forthcoming which can definitely throw light that he was communicated that the LOA has already been issued. He is aware of it. Yet he consciously, deliberately suppressed.
Yes.
I tell you, if that is the evidence that comes before us.
Yes.
That is, I can share. My brother will also join. I have already delivered. I take the same very seriously and will not let anybody go.
Yes.
So merrily while walking from the corridors of the High Court.
That
That's special and making the courts believe what is the existence by
I am just telling you other case in the vacation. 1 second, Mr. I knew manager. 1 second, Mr. Manager.
That is, I know.
You have made enough submission.
There is no difficulty. I am aware of it. But since there was not a single order was.
No, in the vacating also they don't say that I knew when I suppressed it.
So, Mr. Roth, this can't be.
That's fine.
Because it requires an evidence to be gone into whether.
That's fine. Your Lordship will consider the prayer. Your Lordship will consider the prayer for the documents to be filed by us before your Lordship. Now the submission that was made, that all the documents, technical qualification documents were uploaded. All the documents are uploaded. Kindly see page 20 of the writ petition. Just see your para 20. Just see what is your pleading on affidavit. Kindly see. Your Lordship will definitely dismiss the writ petition on this ground. How have you misled the Honorable Court? Kindly see. Para 20.
Para 18, 20.
Para 18 and 20. My Lordship, kindly see. What are you saying before the Honorable Court and what are you submitting before your Lordship today? Para 16. Kindly see para 18. Your petitioner state, Lordship, what is your? Your petitioner state that the 2025 tender did not contain any clause corresponding to clause 10.4, imposing such an automatic technical invalidity solely on the basis of non-uploading of specified FST certificate and OEM authorization at the bid stage. 2025 tender eligibility provisions under clause 10
and its explanation 10.1 to 10.5 contain themselves to work experience, financial turnover, bid capacity, and related formality without any such draconian requirement rendering bid ipso facto invalid for non-submission of technical certificates along with the offer. Your petitioner state that introduction of clause. Your lordship may skip over 19, then straightway come to para 20. What are you saying here on affidavit? Your petitioner state that petitioner number 1's bid in 2026 tender has been rejected on the ground that bidder has not submitted technical certificate by RB letter number so and so, and the petitioner was thus treated technically non-suitable. The said ground of rejection directly corresponds to newly introduced clause 10.4 of 2026 tender, which makes the non-submission of FST technical certificate, OEM authorizations, so and so, dated so and so, or a ground for treating the entire offer as technical invalid. Copy of the said rejection update by so and so is this, Miller. Nowhere does he say that he has uploaded these documents. Then I just request your lordship to see the additional affidavit. From there, their own additional affidavit, your lordship will conclusively opine that he has only uploaded two third essential term you have not complied with as per your own affidavit. Kindly see the additional affidavit. Themselves they have filed money. Kindly see the additional affidavit. They have filed it on 18/3/2026. Kindly see that is at page 8. Just see page 8 of their additional affidavit. Kindly see. This is your own admitted document. The state is not required to. You have filed it. Now, as per your own uploading, those three essential documents which will make you eligible in the technical bid, you yourself admit that you have uploaded only 2 out of 3. Kindly see page 8, madam. Once again, so if you want to assist, please go that side. Kindly see page 8. There are three documents required. They are epoxy, wash machine, and panel. These 3 essential terminal. If your lordship would see, kindly page 180. Before I take your lordship to that, kindly see page 180, which makes the entire tender mandatory. Kindly see page 180. Just similar page 180 plus 1.1. That's all, Lord. I'll show this to your lordship. Kindly see. But it's a public work, railway work involving almost 90 crores of rupees, and page 180, my lords, may kindly see. Clause 1.1. Which makes the whole compliance mandatory. Page 180. But you got it.
Yes.
Kindly see page 180, my lord. Kindly see. Then I'll take your lordship to that additional affidavit. I'll just demonstrate before your lordship how has he failed to comply with the essential term. Admitted. Page 180, technical certificates. Clause 1.1, page 180. Technical certificates. As per, as per Railway Board letter number so and so, project so and so, dated 25/11/2024.
Uploaded it mandatory.
Last time it is mandatory. So without that, it will be rejected. Kindly see their own document. They have uploaded 2 only as per admitted position. Their own additional affidavit. Kindly see, my lord. That's the admitted position, my lord. Kindly see page 8 of their additional affidavit. As per them only, they have uploaded this. They are one wash machine and other is epoxy. The panel, they have not. That is their own affidavit, my lord, at the top of this page once again. This is your affidavit. Kindly find. Additional affidavit dated 18th of March 2026, filed by additional affidavit on behalf of the petitioner. Kindly see page 8 of this affidavit, my lord. Kindly see at the top of the page.
Yes, sir. 2ABC.
Yes, third paneling document you have not uploaded. Now this is the admitted position.
There is no such admission. He will not use the word admit.
Out of these 3, out of 3, if you upload 2, third one is additional.
1, 2, 3.
Please. Why you are unnecessarily jumping? This is the document.
Yes.
It is downloaded from the website of
They have. They have. No, that is their document, not downloaded. They have downloaded it to the railway authorities, submitting the documents through this document. This is their document.
What is this? This is the tender qualification or what?
Kindly see, my lord.
Neither wanted to understand.
My lord, yes, my lord, I'm showing it. That it is submitted. Let us see the affidavit, my lord.
I'll answer your lordship.
Let me argue it, then you will answer. Allow us, Mr. Banerjee, allow us to make out our point, then you will reply. Yes.
Page 5 at the top.
Allow us to make out my point, Mr. Banerjee, court is never asking you.
Techno-commercial
tabulation.
Answer the query.
My lords may kindly see additional affidavit that it is submitted that petitioner company is filing here
This
with
is the document maintained by the tendering committee or what?
Tendering committee.
tendering committee, technical tabulation tendering committee. Yes.
So tendering committee.
Yes.
They prepared 3 documents.
2 documents. My lord.
Oh, top page you will find 3. Page 8.
At the top,
Brackets are there. That means the 3 documents are there.
this
Brackets.
this panel.
But we don't know the technical term.
That the lordships are correct.
We find that there are 3 commas, 2 commas.
Right.
That segregates 3 independent
Documents, right, my lord? Correct, my lord. Absolutely.
What is the nature of the document?
Your lordships are not, nor we also.
There.
Yes.
I can only correlate with epoxy. I can
No.
The other terms I cannot.
No, epoxy, what was required is epoxy flooring. What they have given is epoxy paneling. It's different thing.
Let me understand this. So documents are there. Now the question is, we already must have uploaded those like what you have. Yes. They are coming up, if they can demonstrate from impeccable evidence that these documents were in fact uploaded. It is a fault on the part of the authority because they are harking much on our expression or a tentative finding of nepotism and a favoritism and
that's a different aspect you will satisfy
of such a nature. So that is why one has to understand,
right,
beside the matter,
yes,
that what is correct.
What in fact is uploaded.
The authorities are found
yes
to have committed.
Yes. That's fine, my lord. That's fine, your lordship.
Will your lordship just give me 2 minutes, my lord? Yes. I'll just point out.
I thought sir, give me 1 minute, please. 1 minute, please. Look, I thought you were going to take a point of maintainability on law. I want to conclude my submissions because I want to rely on one judgment.
Now, what is your point of law?
Yes, Manoj. Point of law is this, Manoj. He wants to raise the issue of having been disqualified in the first tender. First tender was floated. First tender was cancelled for a reason. The reason being it did not contain a very relevant mandatory requirement, that is the technical eligibility criteria.
It is not mandatory.
No, I'll because there is suppression. There is gross suppression. What he wants to flog a dead horse, man.
That is what I'm trying to show to your lordship.
That is when he must get an opportunity to deal with those allegations. That what he has suppressed, then we can definitely say.
My lord, my
39 rules for, you know very well.
My lord, my difficulty is.
Party had interest, you can come, file an application and order 39 rules for, and you feel that you are suppressed, you have to be on.
My lord, all that will.
For the meeting has to come.
My lord, but my difficulty is this one.
Taking a very, very pertinent function of law.
Because he has waived his right. That is the point of law I wanted to make out. He has waived his right.
I mean, here the whole matter.
My lord, he has what is right he has.
What I want to submit, my lord, there is a responsive point of view by Supreme Court decision.
Just a minute, I am just submitting. Last occasion I submitted because some technical issue is coming. That's why I considered the court that I will ask the official not to. It is a traveling by the passengers from the general coach to AC coach, and is a maintenance party's concern. So initially, what tender was floated, which was cancelled because of technology, that very important issue was not brought to the condition of the tender. That's why it was cancelled. And second tender was TS participant. I am not that way. Only thing is this, because the entry model, lordship, they hear it about the maintainability, all these things, I want to put my. Let them continue.
We are this matter on Monday. We will decide it finally.
That's right.
In the meantime, if they want to give a rejoinder, they can give a.
They can give. No issue.
May one thing I suggest, my lord. What I am praying, my lord, lordship may allow us to handle the tender subject to outcome of the writ petition.
No,
because it is a maintain over the trend. Without tendering, finaling process, the trend cannot be done by.
If the Thursday, Friday, Saturday, Sunday, 4 days, 1 day is not.
Subject to hearing on Monday, my lord, we are happy. Yes, it will come on Monday in the week. Your lordship.
May I pray 2 p.m.
And the fact that the delay was caused.
Don't worry, they will not drop their undertaking. They will not drop.
No, I have full faith in my learned senior friend. It was there in the order. If it goes missing, it means something else. Kindly, not just that much on civil record. Till Monday gives us that. If he's giving that undertaking, let it just be recorded. Not kindly come.
Yes, my lord, the cancellation I have given.
I am there.
35, my lord. 35 here, iris of this.
Minimum 15 to 20 minutes.
Well, 35, where the rights of the statute are.
Can we fix on the proponent on the next week?
Yes.
Five.
Can you finish within 1 minute?
Let's file an affidavit, my lordship will permit me to file an affidavit.
Tell you in 1 minute, my lord. An order was obtained from this honorable court. Everything the encroachment. I'm sorry, my lord. Was passed. I stand corrected. I apologize. My lord, that order was passed by this honorable court in the year 2024 regarding construction of a road, my lord, over a government block. There were certain encroachers, they were evicted by virtue of this honorable court's order. After that, my lord, if I may take you to the order dated.
What? Tell me already.
Construction of the road, my lord. This honorable court has passed an order to take instructions as to why the construction work hasn't started even after eviction of the encroachers, my lord. Now the construction work has started, but due to intervention of the rival parties, my lord, the political parties, they have stopped construction of the work. And if it is not commenced, my lord, the rainy season will commence, and as a result, the construction of the road.
The work was continuing. Day before yesterday only, my lord, there was some intervention. It has been held up. We have written to the SP, my lord, for police protection. Once it is granted, my lord, we'll again continue the work.
My lord.
So it is a tribal.
Pass order in that line.
Yes.
Pardon me, Your Honor. This writ petition should be attached to the writ appeal number 360 of 25. Here the petitioner was opposite party there in the writ appeal. After getting the notice, he have filed this PIL.
What PIL is concerning the construction?
Yes.
What writ appeal?
Writ appeal was
relates to an encroachment order against him, removal. That's a separate issue. It is not connected with this issue. Why you are?
He was there in the opposite party.
Suffered an order. Once he has suffered an order, he does not want anybody to be there. That's a point.
And that order was the subject matter of writ appeal.
Oh, that is not there. That is a different. Here he wanted that the construction of the road should be there. Commence, but because of the obstruction being created, it has stopped. Now they have already close to the SP. Nobody can stand in the way of completing the construction of a road. Nobody.
But
it is.
It remains.
Or it was repair of the road.
Construction of a patch of the remaining part of the road.
Right remains this opposite party. This petitioner was.
How? How? Tell me. An eviction proceeding is initiated against him. He has suffered an order of eviction. He has been thrown out. Eviction proceeding must have been initiated against you. He has passed an order. You have been thrown out.
I have challenged that in the writ appeal.
Yes.
I have challenged that in the writ appeal.
Correct. You have been thrown out. If the construction continues, if you win, you will be there.
Right remains. Eviction was for.
Your writ petition is dismissed, sir.
My writ petition was not dismissed. I was not being noticed there.
He was the encroacher, my lord. He had appeared, he had suppressed certain facts. After due consideration, the honorable court has passed the order, my lord.
Exactly, the writ petition copy was not shown on me. My name was not being also mentioned there. land or the government land, the matter is pending before.
That has
the
already been
petitioners.
decided, my lord.
No,
Yes,
it is yet to be decided.
it's already been decided.
Already there is a PIL earlier. But bypassing that earlier order, they have approached the single judge.
Below item 39, below, there was an order by your lordships on 11th of March directing issuance of notice below. There was a delay of 1 day below due to technical issues. It is there.
This control, the office is directed to accept the legal counsel. Affect the service.
Item 38, there is a delay of 1 day and is requisite. And the opposite party has already entered appearance, my lord. The opposite party has already entered appearance.
Item 55.
For that reason,
The matter your lordship had heard it substantially and posted it to Monday. Will not be taken up with spilling over. But your lordship may take it up. Monday at 2 p.m. my lord. Your lordship.
Item 54, there are 5 meters. One matter your lordship stayed in. And so far as the other 4, it is not yet, notice is not been issued. Your lordship may take up the application. But there is no interim order. Government is now, yes, in one matter. But that, these are not connected.
Order is specific.
Specific for that particular case.
Keep this matter on Monday.
I may pardon item 54. I am